Let's begin our webinar today, and I'd like to welcome everyone who's joined us and turn over the mic to Elder Larry McDermott to kick things off in a good way.
Miigwech, Larry. Kway Kijimanadu. Walamzi Indigenous Costs, Makwendotum, Shabatabajan First Nation Indigiba. Chimigwech, Anik Mishumas Binung, Chimigwech, Wabanung, Shawanung, Ipanja Jis Kamoj, Kawidi Nung, Chimigwech, Kakino Kegoga Zidoin, Chimigwech Kijimanadu. Chimigwech for everyone who has joined us, for the circle that has been organized, for all the effort that has gone into making this webinar possible. And Chimigwech for those basic elements of life, Nibi the water, the air, Mashomas the sun, and Jojo Aki, our Mother Earth. And as we come off this holiday weekend, we're mindful of those animals, those plants that have fulfilled their responsibility to creation and have shared with us to give us strength to carry on with our first responsibilities, that is to celebrate life and to strategize, to work together for its continuance. And in that spirit, I open the council fire and turn it back to you, Larry. Miigwech.
Masi, Larry. And to everyone who's joined, my name is Larry Innes. I'm a partner at Ulfius Clare Townsend, practicing the area of Aboriginal and environmental law. I'm also the lead of the domestic law and policy stream within the Conservation and Reconciliation Partnership. And I'm based here in Yellowknife, Sambake, Chi-Dragis territory in the Northwest Territories. And it's my pleasure to invite you all to join us in this circle today that Elder Larry has opened. And we will be focusing today on the Doctrines of Discovery. This is part of a Legal Innovations webinar stream that we're running throughout the fall and into the new year through the CRP. Last week, we hosted a webinar on Indigenous and Natural Law, the foundations of IPCAs, featuring examples from the Mi'kmaq territory. That recording will be available shortly. We also have a concurrent stream on governance and IPCAs, which also launched last week. And the next webinar, called Land Relations Planning and IPCAs, focusing on examples from British Columbia and the Yukon, goes live on Thursday. All of this information is available on the CRP's Virtual Campfire Series page, and you can sign up in the same way you did for this webinar to be notified about future webinars. So a few things just before we begin. This is a Zoom, and as everyone knows, the mute button is the most important thing. Everyone has their mic muted now, and please keep it muted so the speakers have the opportunity to present without interruption. We will provide opportunities for Q&As. We're going to do this in two phases. After Professor John Burroughs speaks, we'll open the mics for a short Q&A. And then at the end of the session, we'll have a more general Q&A, which I will moderate. This session is being recorded. For anyone who doesn't want to be part of the web stream feed, you can turn the video feed off on your screen and only your names will appear. This recording, as with the others in the series, will be hosted on the website and it will be available for download. That's the housekeeping. So a little bit about what we're going to be discussing today. First of all, the CRP, or the Conservation and Reconciliation Partnership, is a network supported through the SHRC and Indigenous university and not-for-profit organizations who have come together to examine how conservation practice can be transformed through the principles of ethical space and two-eyed seeing, guided by an Indigenous Elders Lodge and a number of working groups. So we're in the second of what will be a 7-year work program hosted at the University of Guelph that involves several streams. The stream that I'm leading, that this seminar is part of, focuses on identifying the opportunities and the barriers in Canadian domestic law to implementing Indigenous jurisdiction over lands and resources, whether that jurisdiction is being exercised through Indigenous law, through Crown law, or through Crown Indigenous partnerships. We'll be posting frequent updates on this work throughout our various social media feeds, and of course on the CRP website. Our topic today is a foundational topic. We're going to be exploring the Doctrines of Discovery. This is important because it should be increasingly clear to everyone on the Zoom call, but certainly to everyone in Canada at this point, that we have inherited a number of shaky legal foundations. Probably the shakiest of all of these foundations is the Doctrine of Discovery, the fundamentally racist premises that has been used to justify the assertion of European sovereignty over Indigenous nations for hundreds of years. Despite the fact, nearly 40 years after Canada adopted a new constitution in 1982, which recognized Indigenous rights, and despite the work of the TRC, the Truth and Reconciliation Commission, Indigenous governments and leaders across the country, and Canada's own commitments to implementing the United Nations Declarations on the Rights of Indigenous People, the echoes of the Doctrine of Discovery still resonate throughout our case law and are still relied on by our courts. By demystifying these concepts, by calling them out, by shining some light, if you will, into these dark corners, it's our hope that we can forge some new relationships based on the recognition of rights and the recognition of the rightful place of Indigenous nations, Indigenous governments, and Indigenous laws as part of Canada's sovereignty and as part of what we hope to build as a nation. So in this seminar, we're going to hear from some of the leading experts in this area. You've already had the opportunity to enjoy a brief introduction to Larry McDermott, who is an elder in Algonquin from Shabuwato-Benjamin First Nation. He's also the executive director of Plenty Canada and serves as an elder advisor to Canada in its Target to Pathway 1 process, and is a founding member of the CRP Elders Lodge and a significant contributor to our work. We're also going to be hearing from Professor John Burrows, who's the Canada Research Chair in Indigenous Law at the University of Victoria Law School. John is perhaps one of Canada's leading Indigenous scholars in this area and has a resume which is far too long for me to read in the time available. You'll have the opportunity to hear directly from John on this. We also are joined by Professor Aimée Craft, who is an Indigenous Anishinaabe Métis lawyer now at the University of Ottawa. She's an internationally recognized leader in the area of Indigenous laws, treaties, and water, and she prioritizes Indigenous-led and interdisciplinary research, including visual arts and film, co-leads a major research grant on decolonizing water, and works with Indigenous nations and communities on reinforcing Indigenous relationships to the need to water. And we're very pleased to have her here. We also have Rayanna Seymour-Hourie, who's also a Anishinaabe from Lake of the Woods in Treaty 3 territory, who's a staff lawyer at West Coast Environmental Law, working as part of the RELAW, or Revitalizing Indigenous Law for Land, Air, and Water program based at the University of Victoria. Her work is focused also on water law and how the laws and the teachings that water carries can transform our relationships to the natural world. In our webinar today, we'll begin with John Burrows, and he'll start off by introducing us to the Doctrine of Discovery and how it was instrumental in settler colonialism. So John, without further ado, over to you.
Bujun and Dinweb Ganidok, Nichinish Nabeg Nich Marzig, Giganos Indigenous, Neashi Winigiming and Donjaban, Gigin Dodem. I'm grateful to be with you today and send my best wishes to you. So wonderful to have that introduction from the two Larrys, and wonderful to be able to be at the end of this time of remembering as we just went through Thanksgiving weekend. My mother had a stroke this past weekend, and so I'm remembering her in so many ways. She's in the hospital and her voice is affected now. She's not able to speak. And so I hope that my voice carries in ways that she would intend, as I've tried to be her good student all these years. Today, speaking about the Doctrine of Discovery, I want to talk about how it assumes the inferiority of Indigenous peoples and therefore must be abandoned. It's an improper doctrine that is based on racialization, a stereotype that considers Indigenous peoples to be lower on the scale of social organization and therefore not have the same rights to governance and land relationships that those that subsequently arrived would claim for themselves. This Doctrine of Discovery is an ancient doctrine. It can be traced through time, but you find in the Middle Ages during the Crusades, when there was justifications given for Christian nations and leaders to go and try to liberate the Middle East from Muslims, you have these kinds of proclamations. Pope Innocent, for instance, said, is it licit to invade the lands that infidels possess and take what is theirs? That's the question that he posed. And then the answer comes, yes, it is, because the Pope has jurisdiction over all men and power over them in law. And then through this power, there can be this spreading of law that flows from Christian nations that assumes that the nations that are already in possessions of their lands do not have the ability to govern themselves and take up that land use. This doctrine continued through the time of the Portuguese and their transit around the world, and the Spanish with their transit around the world. And you see donations by popes to European powers, both Portuguese and Spanish powers, such that Indigenous peoples' lands were considered and governance was considered to be undermined by these donations. You have this from Christopher Columbus, Pope Alexander writing, Columbus discovered very certain remote islands and even the mainland that hitherto had not been discovered by others, wherein dwell very many peoples living in peace. And then by the blessed authority of the Almighty God conferred upon us in blessed Peter and the vicarhood of Jesus Christ, they go on to hold that all the kings, here in this case, the kings of Castile and Leon, forever, together with all their dominions, cities, camps, and islands and mainlands, are found to be discovered and to be in discovery by these Christian powers. When the Indigenous peoples encountered the Spanish in the New World with this doctrine, they were asked these questions. Actually, notaries would make these statements as they encountered Indigenous peoples. That is, their highness, kings and lords of these islands and lands of these terra firma, as best we can ask and require you that you consider that we have said to you that we take these lands to be ours. And then the idea is that if they accept these lands to be the Christian lands of the Spanish kings, then they will be in peace. And if they don't accept that proclamation by the kings of Spain, then if the crown comes in and takes those lands, this requiremento says it will be the fault of the Indigenous peoples for not abiding by those things. You see these ideas passed along through time, eventually going to the British kings, picking up many of these same doctrines. And with these doctrines, you find this donation again of power. Here in the British charters, it says, we do by these letters patent graciously accept and agree to the humble and well-intentioned desires of propagating Christianity, but in the process undermining the lands and governance powers of the Indigenous peoples that were in place. So you've got, basically from about 1000 to 1600, a long history of assumption of the inferiority of peoples that were being encountered by the Portuguese, the Spanish, and the British, and through requirimientos and papal declarations and British charters, assumptions that there is no authority that these Indigenous peoples would have in relationship to the crown donations that were backed up by the papal authority and then eventually the political authority. In 1608, there was a case in the British courts called Calvin's case, and he kind of put this into legal doctrine where he said all infidels in law are perpetual enemies, for the law presumes not that they will be converted, and that a pagan cannot have or maintain any action at all in a king's court. And so Indigenous peoples, those that are being encountered by these crowns, were considered to be perpetual enemies to the state, and that they could not maintain the actions to establish their titles or their governments in the king's courts. And this goes on: if a Christian king should conquer a kingdom of an infidel and bring them under his subjugation, then by the law of God and the law of nature, they're considered to be the lands of the king. So there you've got a case in 1608. Now this doctrine comes to Canada's highest court at the time in 1888 in a case called St. Catherine's Milling and Lumber Company versus the Queen, where the court calls the Indian title personal and usufructuary and dependent upon the goodwill of the sovereign. Something that is personal can only be held by the Indians. The usufruct is just a right to sort of take the berries and fruits off the land, the meat off the land, without having any other rights in it. And so again, just like in the Columbus or proclamations, or with what you saw with Pope Innocent, these people don't have any rights independent of the goodwill of the sovereign. And then the court says it's been all along vested in the crown, that is the title of the crown, a substantial and paramount estate underlying Indian title. And then Indian title is considered a mere burden on the title of the crown. So the Doctrine of Discovery gives the crown all the underlying rights to land and the overarching rights to government through these donations, through this presumption of the superiority of British, Spanish, Portuguese, papal forms of authority. This is reaffirmed in 1990 in the Supreme Court of Canada in a case called the Queen versus Sparrow. This is the first case to talk about Aboriginal and treaty rights. And the court there says there was from the outset never any doubt that sovereignty and legislative power, and indeed underlying title to such lands, vested in the crown. So there we go, 1990, the Supreme Court of Canada says that legislative power and sovereignty vests in the crown. And there's never any doubt about that. And that doubt comes, or the no doubt comes from these donations that go through time, assuming the superiority of the crowns. This is again picked up in the Haida case, which is in 2004. There's a good statement made by the court. Put simply, Canada's Aboriginal peoples were here when Europeans came and were never conquered. That's a great statement. If there's no conquest, then you might wonder why discovery should be a part of our law today. But then they say in paragraph 53, however, the duty to consult and accommodate Aboriginal peoples to infringe their rights flows from the Crown's assumption of sovereignty over the lands and resources formerly held by the Indigenous peoples. Right here, the Haida people had never surrendered their land, never given it up to the Crown, never entered into a treaty, never agreed to have another government displace their government. But this assumption of Crown sovereignty is the power that enables them to take the paramount role. In 1997, there was a case called Delgamuuk versus the Queen. And in that case, it held that Aboriginal title is a burden on the Crown's underlying title, right? So the Crown is the underlying title again. Indigenous title is just a mere burden. However, the Crown did not gain this title until it asserted sovereignty over the land in question. Once again, title comes through Crown assumption or assertion. And then here's the really significant statement, paragraph 145 of Dalgamuk. Because it does not make sense to speak of a burden on the underlying title before that title existed, Aboriginal title crystallized at the time sovereignty was asserted. So how did the Crown get title? Through this process of crystallization, as if magic crystals were sprinkled across the land in the assertion of sovereignty that dispossessed Indigenous peoples from their lands, dispossessed them from their ability to have government. The court recognizes this is problematic, right? They say it does not make sense. Because it does not make sense to speak of a burden on the underlying title before that title existed, it doesn't make sense. But because it doesn't, well, how are they going to make sense of it? Aboriginal title crystallized at the time sovereignty was asserted. Not much of a justification. In the Silcotin case in 2014, coming from the Supreme Court of Canada, the court said, paragraph 69, at the time of the assertion of European sovereignty, the Crown acquired radical or underlying title to all land in the province. They just do this through mere words, through mere incantation. Right? This incantation, which spreads this crystallization, is based on assumptions. It's a bootstrapping exercise without any foundation. It just exists in the air and is not connected to the facts on the ground that Indigenous peoples were here, are here, and have never given their broad assent to this overarching sovereignty being applied to them and this title being undergirding their own title. And yet the court acts as if. And by acting as if, that seemingly gives them the authority, without persuasion in my view, to be able to take these doctrines and run in such a way that Indigenous peoples are not able to be assumed to be the owners of the land, not assumed by default to be the governors of their land, right? Because as the Supreme Court in Sparrow said, from the outset, there's never any doubt that underlying title and sovereignty and legislative power rested in the Crown. So what are we to do about this assumption of inferiority? There's another story. It's a story that is found in the treaties of Montreal, the treaties of Niagara, the Dish with One Spoon Treaty. It's a treaty of, it's an understanding of intersocietal working out of relationships that doesn't assume inferiority, but commingles in Indigenous and non-Indigenous systems through a sui generis or unique way, morally and politically defensive. The conception of Aboriginal rights would take account of both the Indigenous conceptions of law as well as what the Crown thinks they're doing. There is another story that can be placed beside this Doctrine of Discovery, but so far the Doctrine of Discovery is winning out, even though there's places all along the jurisprudence that you can come to counter views. Even in these older medieval sources with what the Pope was saying, there were people that were disputing what the Crown's and the Pope's donations were. Victoria, who was a Spanish jurist, said this Doctrine of Discovery is ridiculous. There's no way that that could give the rights to the land that are already possessed in another. Gentili and is another person that came to that view. Amongst the Puritans, there were many dissenters. They called this, they said the Crown was engaged in the sin of the patents. That is, patenting land, giving land to non-Indigenous peoples by document without the participation of Indigenous peoples was called a sin in the ecclesiastical and common law traditions. So what are we to do with this? Well, we have obviously a struggle on our hands, but the struggle is quite easy on one level if you consider we don't want our law to be based on assumptions of superiority of non-Indigenous peoples over Indigenous peoples. We don't want this assumption to be really the foundation of our law. Shouldn't the foundation of our law be negotiation, participation, free, prior, and informed consent? Isn't that the way we aspire as Canadians more generally to work, which is in a democratic way, which respects the rule of law, which would be rooted in the laws of the people that were here prior to the arrival of others, and that you would then build law upon that first law to create a more legitimate and just system. Until we do that, we are left with a racist, colonial foundation to Canadian law. And stop. There's no other way of understanding what's going on from coast to coast to coast in our law. As long as we start with propositions from the outset, there was never any doubt that sovereignty and legislative power, and indeed underlying title to such lands vested in the Crown. We cannot continue to proceed in that way because people were here and are here, that they raised substantial doubt about Crown legislative authority and sovereignty, and substantial doubt about the Crown's ability to claim title in these areas. They did so through treaty, and they do so every year through protests and blockades and occupations, where they stand for these principles that our law should be formulated on a greater degree of respect for humanity and for the dignity of peoples and the dignity of their relationships to place. It's not that many Indigenous peoples do not want to find good relationships with those that have subsequently come and live amongst them, but it's to build that on a better foundation. Until we do, I want to leave with you some words from Michel Foucault, who's a philosopher who said this. He says, "Power is war, a war continued by other means," which implies that the relationships of power that function in society rest on a definitive relationship of force that's established at a determinative, historically specifiable moment, in war and by war. That is, it instills and tries to instill the reign of peace in a civil society. That is, it implies that it suspends the effects of war and neutralizes the disequilibrium revealed in the final battle. The role of political power is to perpetually reinscribe the relationship through a form of unspoken warfare, to reinscribe it in social institutions, in economic inequalities, in language, and in the bodies themselves of each and every one of us. What Foucault is saying here is that we might no longer be in the wars like took place in the Crusades, or what the Spanish and the Portuguese were doing when they launched the conquests of the Americas. We might not be in the wars that the British found themselves in when they first dealt with Indigenous peoples in the Caribbean and in the Americas. But just because we suspended the state of war doesn't mean that we haven't perpetually reinscribed the assumptions that were in that war that the British brought to that conflict, or the Spanish brought to that conflict, or the Portuguese brought to that conflict, which is Indigenous peoples are inferior both in land and governance. And so have no doubt, this is inscribed in our social institutions, our economic inequalities, our language, and in our bodies themselves, right? We carry the doctrine of discovery's harms in our very bodies. And so we need to do the work to overturn this doctrine and to see it for what it is: vile, racist, colonial, and not consistent with our democratic aspirations, and not consistent with the many other streams of Indigenous law that are across the country, and even the streams of Canadian law, which I've tried to write about at great length. There are many parts of Canadian law that would not uphold this way of viewing the world. They do say we're never conquered. They do say this, that the doctrine of terra nullius never applies in Canada. They say that in the Silcotin case. So if the doctrine of terra nullius never applied and conquest isn't a part of our law, how can we keep acting as if it is? Because we reinscribed this through our cases through all these years, and we need to get over this assumption. So that's it. I'm looking forward to a few minutes of questions, and appreciate the time that you've taken to be with us today.
Masito, John, and we'll open the mics now, or people can put questions into chat. And if someone has a question for Professor Burrows, please raise it.
I can ask one.
So can I.
Go ahead, Larry.
Oh, you go ahead, Justin.
Okay.
I didn't think I'd get this chance.
I'm actually reading your article right now, Professor Burrows, the durability of terra nullius. Great article. And I was wondering if you could say more about how the Supreme Court decision in 2014 both delegitimated and at the same time reinforced the doctrine of discovery, and kind of what the implications are for future title cases, I guess.
That's right. So you have to beware of the danger of a single story and recognize that nuance is sacred. So I've given a strong version of that doctrine of discovery, which is definitely there strongly in our law. But there's also other parts of the law, as I tried to say a moment ago, that could help you see possibilities for overturning this doctrine. So for instance, in this article, The Durability of Terra Nullius that I wrote in 2015, I make the point that when the Crown is asserting an interest in land where title has not been extinguished, the Indigenous group can come forward and say to the Crown, you don't have any rights to this land because you've never entered into treaty, you've never engaged in your own legal processes, which are in the Royal Proclamation, which are in Section 35 of the Constitution. And therefore the Crown says, when you don't do that, Indigenous peoples can prove that they have title to that land. And by proving that title to the land, that means the Crown title is as if it never existed there, right? The Crown, in the right of British Columbia in the case of the Tsilhqot'in case, does no longer have any ownership rights to that land. So that that is the Tsilhqot'in people can do with that land what they would like in accordance with their law. And so it ousts the ownership interest of the province in that land. And since most of British Columbia has not been dealt with through treaty, the Supreme Court of Canada has put forward an amazing proposition which would put the shoe on the other foot, regard land as being held by Aboriginal peoples when they can prove it. But there's the catch, right? When they can prove it. Because it's the idea that Indigenous peoples have to spend the $25 million that might have been a part of the Delgamuukw case, or the $40 million that all the Crowns and Indigenous peoples spent as a part of the Tsilhqot'in case, because it's assumed that the Crown has the land until such time as Aboriginal peoples prove their ownership, rather than it being the other way around. Why wouldn't you assume that Indigenous peoples have the land? They're in first possession, they are the governors of their land. Why wouldn't we assume that they have that authority until such time as the Crown proves otherwise? But that's not the default position. So this case raises a possibility, opens an amazing door, but then puts a lot of hurdles in place at the same time to be able to walk through that door.
Thanks,
you.
John. Larry, I'm going to skip you, not because I'm skipping you, but because you're our next speaker. We have from the chat, Donna Grace Campbell, who asks, how has this doctrine affected the relationship with land, water, and animals?
If the doctrine of discovery wasn't applicable, then Indigenous peoples would continue to be able to reinforce their own laws in relationship to the land. And those laws are often based on the animals as our kin, through clans, the water and the air as for the benefit of all that need that to sustain life in that place. So if the doctrine of discovery wasn't applied and Indigenous law was in operation, not saying that Indigenous peoples were and are saints, and it is possible for Indigenous peoples to use their laws to be violent against others, but the default position within most Indigenous laws is to regard land, water, animals as kin and clan and mutually participatory. And so we wouldn't have the same kind of allocation of authority away to those that are hurting the land.
Excellent. I think we have time for one more. So questions from both Stephanie and Eduardo to similar ends. Basically, given how foundational the doctrine of discovery is as one of our legal foundations, what steps should we be taking to eliminate it from Canadian jurisprudence? Does this require Parliament to act? Is this something we can do through the courts? What are your thoughts?
Yeah, so the key is steps with pluralization. There's not just one step that can be taken. There's a whole bunch of mutually reinforcing actions that we need to take in different spheres. Because again, we have to be aware of the danger of a single story. We have to think that nuance is going to be there as a part of that. So yes, there are things that can be done in the courts. I write about that. Justine just posed a question a moment ago about that. The United Nations Declaration on the Rights of Indigenous Peoples has been enacted in British Columbia. There's a process now for helping that declaration to be recognized on the ground. So that's a statutory route that we could go. Indigenous people's own laws can be revitalized and reinvigorated. Our languages hold keys to understanding relationships to land, water, plants, animals. Aimée has written a lot about this in her work, and you'll be fortunate to listen to her. I know Larry also knows an incredible amount of the spiritual relationship that we have to land. So yes, courts, legislatures, Indigenous laws, spirituality, but then there's education, healthcare, but every sphere has something to say about this. And again, I've spent 28 years now trying to work on this in different formats and different forms, and it's a work in progress. I don't have the answers, but I have possibilities that I've identified with others that really are significant to seeing love, truth, wisdom, respect, the seven, what we call the Anishinaabe, the seven grandmother and grandfather principles. If we can interact with one another in that way, if we can love one another, be truthful with one another, be honest, as I'm trying to be honest here, that I think is a huge key to the work that lies ahead.
Love and respect is the antidote to power.
Absolutely.
Just, I think that was very well said, and on behalf of all of us, thanks for sharing some time with us today.
Miigwech, thank you.
Okay, I'm now going to turn the mic over to Elder Larry McDermott. And Larry is going to focus, I guess, pick up the threads where John carried them to the imperial origins of the Doctrine of Discovery and describe how those threads and the connections that people have to their land have intersected in recent Canadian history.
Miigwech, Larry. Yeah, I'm going to start by reflecting on an elder who influenced me a great deal, Algonquin elder William Commanda, who said that man can make all the laws he wants, but if they're not anchored in natural law, then he will either harm himself or destroy himself. And so for me, that's the starting point. Good friend of mine, Henry Lickers, the first Indigenous International Joint Commission Great Lakes Commissioner, used to joke about the laws of kings and queens. In other words, a law based on hierarchy. And I think that is the underpinning of this story of Manifest Destiny. It was a rationale. There were iterations. Often people think of the US, but of course, I would argue it was hemispheric. So Canada and the US, we may look at each other, point fingers, make judgments who is worse, but it was all pretty bad. But, and to me, this story starts with the Pope issuing the papal bulls in 1493, I believe, rationalizing colonization, rationalizing brutality towards Indigenous peoples if they didn't speak of God in Latin. And it began a process of horrific government policy in the name of colonization. However, there was this tug and pull. So when some settlers, explorers came to Canada, some of them were actually given a glimpse and had an understanding of actually a better society. And I'm thinking of names, but I'm just going to generalize here. So they wrote, and whether they were French, Italian, British, there were a number of people who actually could see this sophisticated arrangement that human beings had and the relationships that they had with the land and water. And some of this later on had influence, but even people like Champlain had a vision at one point of an equality, a sharing of the land. I mean, there were contradictions, of course, but once ideas of not exerting power got back to the kings and queens and the Pope, it was quickly overruled. And nobody would be so foolish as to push that idea, because you wouldn't get your next exploration trip financed. So you had to fit in with this idea of manifest destiny. It was driven by greed. It was driven by hierarchy. It was driven by patriarchy. And I totally agree with John that it has morphed, it has modernized, but the end game is much the same. I think that there's reasons for hope, but I'll get there. I wanted to reflect on what those early settlers encountered, and what they encountered were Indigenous languages. And so we hear about the importance of Indigenous languages, but some of the best expressions, the deeply spiritual expressions that I've heard from elders that resonated with me, is that the Indigenous languages came literally from the vibration of creation, from that deep connection with a tree, or that deep connection with an animal. And it came from connecting, communicating with those life forms. And again, back to Elder William Commanda, I can remember staying up all night with him and watching things like Einstein's theory on relativity, because he was actually convinced that if you pursue the truth rigidly through Western science, there will be a conversion point with Indigenous knowledge systems. And those 7 grandfather principles that John just referred to, I actually prefer his description as the 7 gifts, because that's what I see them as, the 7 gifts given to us for Mino Pamata Ziwin, that is to live the good life. And it's not complicated. You don't need, a huge library of legal books if you follow those 7 gifts. And humanity would live a good life if it adhered and worked with all 7 of them. I say the last one is wisdom. When you have enough understanding that you know how to apply them all together. And so this was part of what those that sailed from Europe encountered. And some of the manifestations were, in my view, sophisticated multilateral arrangements, like one dish with a dish with one spoon. And the dish with one spoon meant that when you had cusp territories, back to Henry Lickers, he and I used to do a lot of work together, and we talked about the 100-mile fuzzy boundary. And within the 100-mile fuzzy boundary, we kept the highest standard of in thinking about 7 generations ahead, about thinking of our ancestors, about thinking of our responsibilities to all those life forms that are incorporated in the Haudenosaunee words before ounce and are incorporated in our celebrations as well. And so when one nation approached another, you lit a smoky fire and announced your presence and announced that you were coming in peace to share the land, to feed your families. And so you actually spent probably at least a day just socializing, reaffirming those higher principles and the commitment not only to each other, to those 7 generations, but to the water, to the land, and all the life upon it. And so you repeated that. You actually spelled it all out. And you polished that bundle. You polished that multilateral agreement. And you did so, and in doing so, you were feeding it. You're giving it strength. And you're giving that relationship strength. There is no superiority about it. As, again, one of my elders used to say, we're no more important than the smallest insect. So that was, by the way, maybe the smallest virus. So that was reflected in our relationship to each other, to the land. And it worked even though we had different Indigenous legal iterations. We found a way to harmonize them in a multilateral protocol. Sounds wordy, but I kind of like to use it. We're actually just reviving some of those protocols and some of those ceremonies in this area, but I'm jumping ahead. So John pointed out the Treaty of Montreal in 1701. There was also an event less known, and it is embraced in the Friendship and Sharing Wampum Belt. There's 3 figures. William Commanda carried that. I had the great good fortune of speaking about it on a number of occasions. One time I didn't know he had it, and he held it up while I explained to a minister its importance in relation to the Species at Risk Act and importance to acknowledging, along with Western science, Indigenous knowledge systems. And I said, we'd been waiting for hundreds of years that in 1764, we had agreed to accept on an equal basis our systems. Let me jump back to that. So 1763 in the Royal Proclamation, and I wanted to ask John about this one because recently a lawyer we both know, Paul Williams Haudenosaunee, wrote a book on the proclamations, just been released. We had a lengthy conversation about the importance of oral law transferred orally, and of course Pathways 1 was based on recognizing each system as valid. One was not superior to the other. And so this was a process, for those who may not know, in which Canada was following through on its obligations, treaty obligations under the Conventions on Biological Diversity and Climate Change. Love to talk more about it, but I better keep an eye on the time. So back in 1763, the Crown under Sir William Johnson knew Indigenous language. He knew ceremony. He had 8 children with a Mohawk clan mother, Molly Brant. And so pipe ceremonies were used to start the day. The negotiations went on for a month in August of 1764. It wasn't all perfect, but there was respect shown for both legal systems. The clear objective was to share the land, not to wrestle it from the other, not to conquer anybody. And in fact, the proclamation was, I would say, brought about because Pontiac had taken 8 British forts and after the defeat of the French, and the Seneca weren't doing too badly themselves. So suddenly this manifest destiny looked like it was going to be a complete blowout. And so now we're all equal. And that probably saved Canada from being invaded by the US in the War of 1812, because, well, General Brock and Tecumseh formulated a very strong alliance. And at that time, General Brock promised to Tecumseh that if the British were victorious, what are now the Midwestern states and the Prairie provinces would become a pan-Indigenous state. And at the negotiations, Treaty of Ghent, this was put on the table. And not unlike now, you had two Americas. You had the South, led by Henry Clay. You had the North, which was more liberal and more willing to negotiate. But the British sent in junior negotiators thinking the Americans weren't all that skilled. They were there in Belgium. They had sailed to Belgium. The British only had to go across the English Channel, about a 20-mile body of water. And so they got caught with flat feet, and they got out negotiated, and there were no Indigenous people there. So this, so what was conjured up was Clay knew that there had been promises made, that there was the honor of the crown, and that they needed to at least go home and look good. So they said, yeah, we honor all the rights that have before been mentioned in 1764, the Treaty of Niagara, or Fort Stanwix in 1768, and there were a few other things on the table. And so the Pledge of the Crown Belt was issued, and but really it was one of those deals where, well, my fingers are crossed behind my back. What I say is not what I mean. And shortly thereafter, the British and of course the Americans abandoned their integrity to Indigenous peoples. And I see that 1815 for me was the end of the relationship and the beginning of the Dark Ages. Long before 1876, that it was particularly bad then. We know about MacDonald and his national policy of starvation and celebrating the starvation of Indigenous peoples, and we know how bad it got. I'm looking at my time and knowing that I think I'm pretty much run out. But what I do want to talk about is that I feel the Supreme Court is kind of inched toward the truth. I think there's been a fear of toppling this vertical system in which wealth is congregated by a few, in which the land continues to be colonized. Whatever the extraction industry is, we pay lip service to sustainability. We pay lip service to climate change. But those are the elements of natural law that I opened up with. Those are the elements of natural law nobody gets away with. You can't fool a judge because it comes from the Creator's design. And if we're in violation of that Creator's design, we're all in tough shape. And so at the end of the day, it's in everyone's interest to live the truth. And the truth is we're all equal. And the truth is all of life is sacred. And the truth is we need to organize our economies, our legal systems around those truths. Miigwech.
Miigwech. Thanks, Elder McDermott, for bringing us forward and reminding us of those truths. Our next presenter, Professor Aimée Craft, will carry on the threads that we're tracing and focusing on the doctrine of discovery and how it continues to inform how treaties are understood, how treaty relationships are lived, and how this affects the exercise of Indigenous territorial sovereignty and jurisdiction in Canada today. So, Professor.
Thank you, Larry. Bonjour, ndine maganeduk kiweten no dini koinishnakas makanaki koinishnakas. Manganando dem. I'm speaking to you from my home territory today, so I'm really pleased to be able to do that and to join into the conversation and to bring a slightly different lens to the conversation. Although I really appreciate already everything that's been said by John and Larry. You'll see that my take is a little bit different and I think complementary to what you've said so far. And I think the dimensions that I want to add are based on historic treaties and the numbered treaties in Western Canada and how that forms and informs treaty federalism as a direct counterpoint to Doctrine of Discovery. And some of the gendered implications of thinking through Doctrine of Discovery and those treaty relationships as they were formed and as they continue to exist today, even through assertions of territorial sovereignty that come about through various affirmations of jurisdiction, like on land birthing. And so that's kind of, I don't know if I can do that in 15 minutes without talking really, really fast. But what I think I'll do is just introduce some of the concepts and hopefully we can have a bit of a discussion following what I have to say. So Doctrine of Discovery, why are we talking about this? We're not in periods of conquest or thinking about the discovery of territories. We're living with an inherited legacy. And I think John has painted that picture quite clearly in terms of this legacy that we've received that actually is not about discovery at all. It's about a concept of inferiority of Indigenous people. And what this doctrine is really about is about creating affirmations of jurisdiction over land or ownership of land, being two different concepts, so ownership and jurisdiction, and who has legitimate or legal interests in that land. Now, what I think is complicated when we're talking about that is that we're not actually talking about land. We're talking about human interests in land. And I think that that's part of what, you know, Elder Larry, you're trying to get at, is that we're abstracting land and all of its components, all of creation, which are so important when we think of how Indigenous legal orders are structured. And we're reducing it to the idea of human interest, and even beyond that to human capitalist interests, rather than human wellness interests that have collective dimensions. So I think that, you know, calling that out right from the start is really important. And so, yeah, the crux of my argument today is that the problem is that we're centering humans under the guise of land, but really we're talking about human interest in land, and Anishinaabe legal orders and other Indigenous legal orders decenter humans from the crux of the legal analysis. And presumably this is where most of the common law goes wrong anyway, is in centering human interests rather than thinking about other than human interests. And this, I think, also carries a conversation that carries really nicely into environmental law and, you know, environmental assessment and regulatory law in many ways. So I want to pick up on something that John Burroughs said in terms of his points that conquest and discovery are not actually affected in Canadian law. They only find notional, or what I'm going to be bold enough to say is fictive, support in Canadian law. And so these are fictional creations within a Canadian legal construct. And so deconstructing them is almost a futile exercise in logic, because they're actually not logically achieved within the Canadian legal construct. So thinking in that way, where do we go? Is it legislation? Is it common law? Is it international law? And so what I'm hoping to do in the bit of time that I have is maybe point to a couple mistakes in the common law, support what John has said, weave in a little bit of treaty thought, international law, and Indigenous legal orders. And like I said, hopefully that leads us into a good discussion. So I want to start with mistakes in the common law with former Chief Justice McLaughlin's assertion in Silcoteen that terra nullius never applied in Canada. That's just factually incorrect if you look at the foundations of Canadian law, but also thinking about how the provinces and land and jurisdiction is treated in Canada historically doesn't align with that kind of affirmation. So if you think of the BC context, the first Lieutenant Governor of British Columbia insists that First Nations never own land. They could be ignored, and this is why there's very little treaty activity within British Columbia. Okay, so we have these original assumptions that are deeply rooted in how the law and politics within jurisdictions within Canada are developing over time. And we could add to, you know, how many mistakes there are in Canadian law, but the other, I think, is in how the Supreme Court has actually brought about this concept of discover that has brought the doctrine of discovery into Canadian law under the cloak of reconciliation, the language of reconciliation. And I wrote a pretty extensive piece on this. I think it's called Neither Justification Nor Infringement, the Mistaken Approach of the Supreme Court. I think my first title was How the Supreme Court Got It Wrong, but I was told to soften the language. I think they did get it wrong. And I kind of regret actually softening the language, because under this cloak of reconciliation, what the Supreme Court does is set up this idea of reconciling something that is prior to something that is either assumed or asserted, and the language is fuzzy around assuming, asserting, acquiring jurisdiction or sovereignty on the Crown's part. So I have in that piece sort of all these permutations that we see in this cloak of reconciliation in Canadian law, where we look at culture, peoples, interests, territorial claims, rights, perspectives, societies, the prior occupation of North America by Indigenous people as needing to be reconciled with these assertions, affirmations of Crown sovereignty, Crown interests, other interests, non-Aboriginal interests, non-Aboriginal people, the common law perspective, broader political community, broader society, the larger Canadian, I could go on and on. So what the court is asking us to do in the court's vision of reconciliation is actually to reconcile the prior sovereignty of Indigenous people with some kind of imposed sovereignty, which doesn't exist in international law. You can't impose sovereignty except through very specific means, and conquest being one of them, where you have two sovereigns and there's a conquest over the other. The doctrine of discovery applies here because conquest is not at play, and John made that point, I think, very clearly. So in that series of cases on reconciliation, and starting with Vanderpeed, the court says something I think that we can attach to, though, now, even though there are these mistakes that are made. One is this, that in Vanderpeed, the court talks about the Section 35 framework as a framework through which the fact, so they're talking about fact, that Aboriginals lived on the land in distinctive societies with their own practices, traditions, and cultures is acknowledged and then reconciled with Crown sovereignty. Okay, so practices, traditions, and cultures are indicators of sovereignty. They're not indicators of prior occupation. So I think the court makes another mistake in attaching these things to this idea of occupation. And I think it builds into its thinking this concept of inferiority, rather than thinking about these practices, traditions, and cultures as actual indicators of sovereignty and territorial sovereignty rather than prior occupation. And these, if you accept that, if you accept what the court is calling fact of living in these distinctive societies with practices, traditions, and cultures, then we can see that sovereignty is not conquered, and continuing sovereignty is confirmed in the Royal Proclamation, Treaty of Niagara Promises, and subsequent treaties. All right, so where does that leave us then if we think about this affirmation of some kind of sovereignty over the territory, then leading to a need to acquire some kind of agreement, some co-jurisdiction, some shared jurisdiction, some what we call treaty federalism, or what Elder Harry Bowen calls agoiduin, which I also talk about in that reconciliation piece. And thinking about that within this section 35 lens is the opportunity at which this shared jurisdiction was actually brokered and negotiated through historic treaties. What's interesting is when we're given direction on how to interpret treaties in section 35 jurisprudence, this core concept of the honor of the crown is always there. And so for presuming actual honorable conduct on the part of the crown, it would have required at that time to act in accordance with the royal proclamation and other affirmations of the crown, and to negotiate these treaties, not on the basis of conquest, because that would be factually untrue, nor on the principle of discovery, that they would be entering into co-sovereign agreements. So if they're entering into co-sovereign agreements in treaty making, that leads us to thinking about treaty implementation also being governed under the law that was used to make those treaties. And so treaties were made in accordance with Indigenous legal orders and should be interpreted today in accordance with those Indigenous legal orders. And you know, I think that there's some really important indications when we look at historic treaty making on how Indigenous territorial sovereignty and jurisdiction is really clearly articulated. And one is looking at how protocols are followed, the places and relationships with place that are present in treaty making, the jurisdictional questions, for example, waiting for others to arrive and not negotiating on anyone else's behalf, so recognizing the autonomy of different groups within the treaty making, and also thinking about this concept that comes up in a lot of the Anishinaabe treaty making and that I'm starting to try to canvas, which is the concept of dark clouds. And so I don't know if any of you have read or heard of the dark clouds as part of treaty negotiations. It's kind of an underexplored element that's brought forward over and over and over again. And I think it's actually the way to explain jurisdiction from an Anishinaabe perspective. So I'll give an example of Treaty 1 because I'm in Treaty 1 and that's my treaty and territory. And when our chiefs went to negotiate Treaty 1, they actually talked about the dark cloud over the negotiations and that it could only be lessened by the release of Anishinaabe prisoners by the Crown's representatives. So where they negotiated at the Stone Fort, there were Anishinaabe that were imprisoned for breach of contract with I'm not exactly sure why they were imprisoned, but they were essentially the demand was to release them because they came under the authority of the Anishinaabe chiefs that were there, and there was an agreement to release them as a recognition of that jurisdiction and authority of the chiefs that were present. So coming back to ideas of what sovereignty is, the language and culture and territorial sovereignty and jurisdiction over spirituality and citizenship and the lands and waters, that's all part of those really important treaty discussions and the way the foundations are set for treaty making. I know we're short on time, so I'm going to quickly, I think, jump to the gender dimensions of jurisdiction that I think is so important to think about historically and in a contemporary context. I think gender has an impact if we look at historic treaties in terms of who negotiated treaties, who had jurisdiction over what, and there is a growing body of scholarship, and I know that elders have talked about this for a very long time in terms of who actually had authority to effect surrender of land and who had jurisdiction and continues to have jurisdiction in relation to water, because water is under discussed in the historic treaties. And I think that these gendered dimensions of women's roles as clan mothers, life givers, responsible for all life, which includes land, water, and all of creation, are really important when we think about the effect of any treaty negotiation and what it was truly meant to achieve, and what it achieved by excluding women from the negotiations. So whether or not you look at treaties as a way to surrender land, the surrender may have been imperfect by not involving the actual jurisdictional actors in the treaty negotiations themselves. I think that those are things that we need to explore when we start thinking about how to unpack and maybe silence the doctrine of discovery as an important narrative in Canadian law. So the international lens that I wanted to bring, I think is probably more than we have time for today, but I think it does have some important bearing. And I just want to remind us that the TRC calls to action actually do call for the rejection and the removal of the doctrines of terra nullius and doctrine of discovery in Canadian law. What the TRC proposed was actually a new proclamation, something akin to the Royal Proclamation, which I think is an interesting, a very interesting mechanism. And I think that the framework for reconciliation being built on UNDRIP in Canada that is called for by the TRC is being given some effect in legislation. And John mentioned the British Columbia legislation. We have legislation in Manitoba, Path to Reconciliation Act, which also pointed to these very important foundational concepts, which was then interpreted by a court as being aspirational. So I think we need to be very cautious about how much legislation can achieve and think about how we need to also concentrate on the removal of these legal fictions within political discourse, Canadian common law, as well as through legislation itself. So in closing, I think that there's an importance to thinking about how we acquire law, and Indigenous legal orders are generally received from spiritual, natural, customary, and positivistic forms. And there's a few variations on thinking about that, but land-connected practices and thinking about how we frame a jurisdiction and territorial sovereignty as being law learnt from land, I think is a very important part of this continued discussion. And those are things that can bring and are meant to bring wellness to land, individuals, families, communities, and nations. And right now, one of the places where I'm focusing my energy is on reclaiming practices of birthing within territory, in addition to work on water and lands, but thinking about that very special connection between women as life givers and the connection between birthing in territory as an affirmation of territorial sovereignty, and that very robust sovereignty that includes citizenship and lands and waters. So I'll leave it at that, and I look forward to the questions and conversation that will flow. Miigwech.
Miigwech, Aimée. And now we're going to turn to Rayanna Seymour-Hourie, who will bring us home with her take on how law as a practicing lawyer, as reconciliation, and about how relearning Indigenous law and practice can contribute to demystifying or dispensing with the doctrines of discovery. So, Rayanna.
Bonjour, everyone. My Indigenous Jean Kutuk Indigenous Cause Makwan Dutem Neongashin Dunji. So my English name is Rayanna Seymour-Hourie. I am a Anishinaabe from Treaty 3 territory, which is Northwestern Ontario and a part of Manitoba. I am a staff lawyer at West Coast Environmental Law, but also the RELAW manager for the program I work in, which is called Revitalizing Indigenous Law for Land, Air, and Water. And so we partner with Indigenous nations in support and capacity building, but also offer a year of pro bono legal services to support in their work on land and water protection. And we use a methodology from the Indigenous Law Research Unit and work primarily with stories. So that's kind of a little bit of background about my work. But I think just kind of building that foundation for what I'll speak to in the next few minutes is just kind of understanding my perspective, I guess. So I was reflecting today of how I'm still a youth, but I'm kind of in that transition to a young woman as well. So I'm in that, space of being a youth and a young woman. And so I think like my perspective of, a lot of different matters is very, very unique because my lived experiences as well as my education, offer my voice to certain things. So I kind of wanted to start it off with the question that Aimée posed at the end of her speech. And I just also wanted to say the importance of mentoring young people too as well. So I've known Aimée for a very long time and she's one of my mentors. So it's pretty cool to be on this panel with her. But she asked how to unpack and silence the doctrine of discovery. And I think I should relate it also again to what John Burroughs was talking about in answering this question, because what he said is like, we need another story to replace the doctrine of discovery. And a way on reaching that new story, I think, is visioning together, visioning with ourselves, visioning with like-minded people. What does the world look like without the doctrine of discovery? And starting from these places, I think it offers much more imagination, much more to have important dialogue. And there might be times when certain things will have to be put on the shelf to have these very important discussions. So like the concept of agree to disagree. Okay, you agree that you have sovereignty. We agree that we have sovereignty. So let's just agree to disagree and let's figure out, how to move forward together. Because I think like what I've been learning in my little limited experience on working with Indigenous nations is that a lot of these important discussions are put on the shelf because certain things can't be put on the shelf, like the agreement to disagree. So I think it's really, really important to, when doing that work, to kind of think about, okay, like, how can we agree to disagree? How can we move ahead in these conversations to figure out solutions? Because, if we continue to disagree, if I'm saying it properly, then we'll continue to stay in this space. So, John Burroughs was talking about this new story, this other story of replacing, the doctrine of discovery. It has to be based on respect. And then we're not even revisioning anything new, because Aimée talked about that original relationship that we had. It's already there. It was already based on respect. It was based on nation to nation, and it was based on Indigenous law and Indigenous processes. So we're not reimagining really anything. We're kind of looking to our past to inform our present and to plan for the future, this better future, this future that isn't based on the doctrine of discovery. So, I think that goes through like changing the assumption. So the assumption of Canadian law is this doctrine of discovery, but switching it with this other assumption that there is already Indigenous peoples here, there is already healthy societies where they were in relationships with other beings, where everybody was sustained and everybody was thriving. So, just replacing it with those truths that, there was a story before the doctrine of discovery. So maybe that's what needs to be focused on, is what that story is. And then I think there's different roles for everybody to play in this new reimagination of our future. So West Coast Environmental Law, for example, is a not-for-profit legal organization, and we focus on legal education. That's one of our things we do. So we have like a lot of followers, right? So we focus on that legal education piece, that yes, Indigenous peoples are here, that they've always been here, that there's Indigenous laws. So we have a certain role to play within, the environmental Canadian, you know, I guess, social institution, but we also have roles as individuals. So, you know, my particular role as a young Anishinaabe lawyer is to decolonize the way I think and to understand that there are certain thoughts and processes that do not come from my bloodline. So what I mean by this is, and I think the biggest example of this type of thought that I think comes from the colonial, you know, way of thinking is that I'm not good enough. And the reason why I think that, I understand, is because there's a huge problem with violence against Indigenous women, missing and murdered Indigenous women and girls. So there's certain reasons why I think that way. And I take it upon myself to understand why I'm thinking that way and replace it with a different story, you know, that I'm good enough, that I'm smart, and all of these beautiful things about, you know, myself. So then I try and determine what's coming from me and what's not coming from me. And that plays like a huge part in how I come to my work, right? So, and that goes to that point that John Burroughs was saying, that we carry the doctrine of discovery in our bodies. And, you know, so there's not only work that we have to do within our professional lives, but it all starts with self. So how do you get that doctrine of discovery out of your body? And I feel like I've been on this journey consciously for the last 2 years, and there's still a long way to go. But, you know, it's much more easier to kind of understand where I am, how I might want to show up to this work, and, you know, what solutions I might have within me, because I'm more, I guess, open or a little bit more healed than I was yesterday, right? And I think it's important to recognize that everybody has a role in, you know, decolonization. It's not just Indigenous peoples. We all live within the same systems. You know, we all were educated in the same systems. So, you know, there's a lot of internal work that needs to be done to walk past that, you know, colonial door. And when we walk through that colonial door, it might even be a few times. So it might be once by myself. It might be once with my family. It might be once with my community. It might be once with my nation, you know, so you might be walking through that door multiple times in your lifetime. And, you know, so I really liked what Larry was saying with the vibration of creation. So how do we kind of, I guess, think of ourselves as a vibration within creation, and how do we want to ripple out good things into the world, right? To support this work, because this work requires us to look past ourselves, because we might not see the benefits within our lifetime, but we're all hoping that, you know, our children or our grandchildren will be able to reap the benefits that we're all talking about. And, you know, I think returning back to Aimée's comments on this inherited legacy, like, yes, we all have an inherited legacy of these harmful thoughts and, you know, all of this racism and all of these different things, but we also have the power to transform that legacy within ourselves, to show our children and those around us that there's another legacy there that we can take up. And this legacy is about reimagining a better future for us all that's based on sustainability, love, respect, and kindness, and all of those 7 teachings that John and Larry were talking about. So I think this comes to story as well, how, you know, Indigenous stories have, so like, we know that Indigenous peoples have been here since time immemorial, and there's stories that are replaying again in the present time. So we're going through pandemics, and I'm talking about racial injustice and the COVID, but there's also, and different natural disasters like floods and droughts, and all of these things, they've all happened on Turtle Island before. So thinking about how did the people deal with those situations, and talking about that, and how might those, how might those stories support us in kind of thinking about a different process, thinking about other ways to kind of come together and reimagine this better future that allows for brighter, imagination. Because I think it's, very, very important to be able to speak from the heart. Like, yes, we're intellectual beings. There's a lot of us who are lawyers and professors and, professionals, but also like we are human. So, kind of reflecting on that and the different roles that we all play within society, and how to show up to our work in a good way, and and this will enable us to kind of move or support in moving that dark cloud that I think is above us again, like as we speak. So, how to unpack and silence the doctrine of discovery is both an individual process, but it's also family, community, and within our respective organizations. But once we're clear on how we feel and how we know this, know these things, it'll be much more, easier to kind of show up in our work to advocate for this way of life. So I just want to say miigwech, and thank you to all the other panelists and everybody for listening.
Miigwech, Rayanna. And we now have an opportunity, about 20 minutes for discussion and questions. And I'd really like to acknowledge where Rayanna took us in her reflections, back perhaps to where we began with a story that, as John indicated, came with colonizers, was grounded in a particular view of the world where Europeans and Christians were held to be superior and all others held to be inferior. The fact that we're still holding on to this story in our courts, that we still rely on this story to justify the dispossession of Indigenous peoples from their lands, even in the face of evidence that dispossession in much of what is now Canada has never actually occurred. There have been treaties made over time. There have been relationships forged over time between peoples and between governments. And we have to ask ourselves, I think, in 2020, are we still going to live under these old doctrines that have really no place in modern Canada, where the TRC, where indeed our Parliament and our Prime Minister has said, these doctrines are discredited and have no place in our nation. So, I'm reminded, I can't quote Foucault as well as Professor Burroughs, but I can quote Monty Python. There's a scene in in the Holy Grail where King Arthur rides up to a group of peasants, and the group of peasants ask him who he is, and he says, "Well, I am your king." And they say, "Well, I didn't vote for you. Who made you king?" And he comes up with, of course, with a story about how, someone threw a sword at him, and that way he became king. And the peasants say, "Well, that's no basis for a system of government." It seems that we're at that point in Canada now, where reliance on these stories, because really, what is a doctrine other than a story that a court tells us, need to be revisited. And as Rayanna reminds us, our relationship to these stories is at once political, but it's also intensely personal. And this is where I think we have an opportunity to talk amongst ourselves today. There's a small, intimate group of 70 people on the call. But please, if you've got questions, shout out or put them into the chat. Masi.
Well, if there's no immediate questions, I encourage questions to come from the panelists. I just wanted to point out the fact that this series of webinars is part of the CRP, and the CRP is the creation of a few, many people involved in the Canada's Pathways to Target 1 specifically was born to work to support the implementation of the the report and recommendations that the ICE committee put together. We rise together. So, you know, the concept of we rise together was a concept that was well thought out, that many on this call participated in, and others. So, you know, there's a number of us Indigenous folks that were worked with folks from the different governments across the country and the provinces and territories, and the different federal families, different departments within the federal government. All the recommendations were debated and are implementable. And I think for those that asked that question, where do we go from here? I think that report and its recommendation can speak to what we can do in the next few years, especially in answering to Canada's commitment to the Aichi Accord and the Paris Accord and whatever other accords or treaties that they will enter into, done in the spirit of reconciliation, obviously, and that spirit will be defined by the different nations across the country. So I just wanted to add that to this discussion and where this discussion was born. And I think it was born back in the when we handed in the report or during the deliberations of the report. The actual date is, I think it was September of 2017 in Winnipeg, when Dr. Robin Roth and Faisal Mullah came to see me and Eli Yenz in Winnipeg when we were doing the Southern Canada or Central Canada gathering there. Thank you.
Merci, Stephen. Now I've got a couple of questions in chat, so let's begin with one from Sarah Mainville, asking how much of Section 9124, and for the not law nerds in the room, that's the federal jurisdiction over Indians and laws or lands reserved for Indians, is steeped in the Doctrine of Discovery, and how should we consider how powers, jurisdictional powers, are shared across our territories? So I'll put that out to the panel, and anyone can take it.
I'll start. This is a very long, I have a long answer, and Sarah, I'd be happy to chat with you about that answer afterwards. But I think essential to 9124 is some kind of rooting in the Doctrine of Discovery. And to John's point, this idea of inferiority, right? So who else do you see named in the division of powers? Are there any other people that are named in the division of powers, provincial or federal? No. Even immigration is a subject matter. It's not about immigrants. So this is a place where in the construction of the Constitution, the Constitution makers allowed themselves to carve out a power over people. And so the short answer to your question is, yeah, absolutely. How much is it steeped? It's pretty significantly steeped in Doctrine of Discovery. And I think that if we look at, you know, how we envision 9124 today, I think that's, because that's the second part of your question. How do you reconsider how powers are shared across territories? I think there's a few different, I think there's three pieces that I would place prominently on the table in terms of a response to that question. One is on redefining cooperative federalism, which is the order of the day currently, you know, thinking about how cooperative federalism is given effect in Canada and approaching it from a treaty federalism perspective. So multiple orders of government, not just provincial, federal, or territorial. And you know, the evolving role of municipalities is one way to think about how flexible the concept is. I'm not making analogies between municipalities and First Nations. I just want to be really clear about that. Very separate. But the idea that there's flexibility within the watertight compartments that were originally potentially envisioned, I think is worth exploring. To that, I would also add as a second piece for consideration, the idea of Indigenous jurisdictions and thinking about the concept of jurisdiction very fully. So you have subject matter jurisdiction, but you also have the application of jurisdiction within a territory. And I think that that's where Indigenous jurisdiction kind of starts to defy a lot of how Canadian law is constructed and how cooperative federalism and jurisdictional decision-making has taken place, is that we don't fit within these very conformed geopolitical boundaries that have straight lines. And we actually define ourselves as Indigenous people by jurisdictions that are outside of us. So coming back to my argument about let's not be too human focused, water moves through these boundaries. I think it's the best example. Water doesn't know these geopolitical boundaries. And so thinking about, if we're looking at water decision-making, how might we look at it within these jurisdictions that are defined by the quote-unquote subject matter itself. Okay, I'm writing a book on that, so that could be a very long conversation, but I'll leave that and just as the last point, point to, what I think is an old doctrine of constitutional law, which relates to proximity. And, that decision maker who's closest to the subject matter should decide. And I think that's, I recently published something relating to COVID-19 and the law, policy, and ethics of COVID-19 and First Nations responses with Deb McGregor and Jeffrey Hewitt. And we argued that this is a doctrine that, taking Rayanna's point, you can agree to disagree on the fundamental jurisdictional question, but if you look at proximity and who's closest and best positioned to make decisions on a lot of the substance of responses to COVID, it's the nations that are directly engaged with their citizens. So that doctrine of proximity can be helpful in kind of setting aside the disagreement, agreeing to disagree, but actually getting real traction and movement on governance issues that recognize Indigenous jurisdictional decision-making on specific subjects. Sorry for the long-winded question. I was so excited when I saw it though. Thank you.
Anyone else want to add comment on that one? I think it's a really important set of issues that Aimé's canvassed very well.
Maybe I could add some real life applications of that concept from the treaty relationship perspective and how our relationship with our territory defines how we represent the territory itself, and the concept of agreeing to disagree. I'll use the Saugeen agreement that Tlusagid negotiated with Canada and the government of Northwest Territories to create the Saugeen National Park Reserve and territorial protected area, territorial protected and conserved area, all within the Tlusagid protected area, protected and conserved area that we named Saugeen. That was based on the treaty relationship we have with the Crown. We entered treaty in 1900. The Crown labeled it Treaty Number 8. We still call it Treaty of 1900. We agreed to share the lands and the resources and to share the responsibility and share the benefits accruing from them. So based on that, and along with some constitutional and Supreme Court and lower court decisions, we made the argument in Canada and Tlusagid agreed to disagree on jurisdictional issues, but agreed that the area was special enough and important enough that we will work together as governments to create a protected area and to govern, manage, and operate it together. So that's an example of how an Indigenous government can fulfill its responsibility in the treaty relationship. Because this treaty relationship is rights and responsibility. I like to say there's rights and responsibility on either side of the $5 bill. And here we have one government, Indigenous government, that was able to do that, and that was last year. So that's the next level of relationship I think Canada and Indigenous governments can negotiate especially with Indigenous governments that choose to partner with Crown governments and the laws that they have also to use in the creation and protection of their territory.
Excellent example. Okay, I'm going to touch on another question.
Just I forgot, we will be doing a deeper dive into this on one of the webinars on IPCA governance in the weeks and months to come.
Stay tuned. Going back to questions, one question which has come up both in the presentations and also in comments left in chat concerns how the honor of the crown, this idea that the crown must behave honorably, fit in to our conversation about the doctrine of discovery. So to the panelists, who wants to tackle that one?
I can start. I meant to talk about this a little bit when I was speaking a little while ago, but I guess I'll just do it now. So I think we're in a time right now of holding people accountable to their actions. So we've seen that with the Me Too movement, holding men accountable to their abusive actions, for example. And so I think it's like, just thinking of where we are, you know, in the world right now, I think how the honor of the crown fits into this conversation on, you know, the demystifying the doctrine of discovery. I think the honor of the crown calls for, you know, Canada to be held accountable and to, you know, just acknowledge and think of how to move forward. So I guess it's not like a complete answer, but I think just thinking of the times right now, I think it's, yeah, it's timely. I'll leave it there.
Pausing for Beth, I may add just a bit of commentary from the moderator's chair that the honor of the crown is playing out in some really interesting ways right now in relation to not just the public interest, but the public interest in terms of the treaty relationship. There was an unlikely decision, if I may say so, from the Alberta Court of Appeal, which concerned an oil sands development in close proximity to a sacred lake for the Fort McKay First Nation, where it was held that the regulator had failed to consider the promises made to Fort McKay by the Crown in proceeding to authorize the development, given that the Crown was at the same time considering the protection of that lake for traditional purposes. And what we might say down east is the Crown can't suck and blow at the same time. It needs to uphold the public interest and to do so in a way that is consistent. So a broader and fuller view of the honor of the Crown would consider Indigenous rights under Section 35. I think it would also consider what many of the panelists have spoken about, which is if we're actually going to give voice to this idea that we're all here to stay, which is another one of those phrases that people off-cite from the Supreme Court, who we are has got to be broader than just us humans. And staying has to be something more than just another settler planting a flag, but rather finding a way to think about sustainability within Canada, within the earth, and as people who are part of a larger community of life, that call to act as though we were all here to stay takes on a greater meaning. I'm going to go to a few more questions while I dig through the chat. Panelists, if you have anything to add. Okay, so there's one more request to maybe dive into, and this would be for Aimée, the concept of dark clouds and the idea of jurisdiction. If you can maybe touch on that.
Sure. I don't want to take up too much time on it, but I think that there's something very interesting about how we come to nation-to-nation negotiations in treaty making. And this is replicated in all of the treaty negotiations, either in the historical record or in the oral histories, is that the treaties are negotiated on that nation-to-nation basis. And that brings with it the full package of jurisdiction and sovereignty which includes that sovereignty over it, the citizens of the nation, right? And so I take that to mean, as sort of starting points in negotiation. And I'm sure a lot of you on the call are negotiators in some capacity, whether it be on behalf of nations or with your small children. You have to come to your negotiation with this very clear indication of how you see your authority to be within that conversation. What brings you to the table, both in terms of, like I was saying earlier, the subject matter, the territory, and also who you are as a decision maker. So who is within your citizenship. And the dark clouds, I think, are an affirmation based on the records that I've seen of someone interfering with jurisdiction. There's an attempt to hide the sun. And those of you who know treaty history will have heard the words, for as long as the sun shines, grass grows and rivers flow. And that's kind of a concept that's been restricted and boiled down to meaning somehow forever. But that's a very simplistic understanding of it. I actually wrote a children's book that's coming out in the spring called Treaty Words. And it's actually about the original treaty on which we model all of our treaty making relationships. And it's actually about that relationship between those three elements that work together to renew, that have reciprocal relationships, that show change over time and flexibility, and looking at those as indicators or a model of how to make good relationships. So I think that the dark clouds is actually chiefs or negotiators on behalf of Indigenous nations saying very clearly, you're trying to place a dark cloud over the sun of this kind of relationship that we're trying to make. So we need to get rid of this dark cloud if we're going to have any chance at a good relationship. And so, thinking about that in a modern context, we can still think about how we look at sunshine, shining, grass growing, and rivers flowing as sort of the benchmark or the standard for good treaty making and what a nation-to-nation relationship could look like. And think about how we remove those dark clouds or how we silence the doctrine of discovery.
Fantastic. Okay, I've got one more question, and this one goes to Rayanna. And it is wanting to know more about the program you're working on, Land and Water Protection. And I think there'll be a request in the chat to get in touch regarding a particular project, the Upper York's sewage system, on behalf of a First Nation working within Lake Simcoe, in particular, how to approach gender, cultural impacts, and other matters. So Rayanna, maybe I'll use this as an opportunity for you to plug the work that West Coast Environmental Law does, which is one of the sponsors of this webinar series, with the RELAW project that you lead.
Sure. So as I said at the beginning, the RELAW program, so Revitalizing Indigenous Law for Land, Air, and Water, we partner with Indigenous nations and specifically support in pro bono legal services for the year. So whether that be drafting, strategic support, or other types of support. So I guess I'll break down the RELAW program. So there's a few aspects to the RELAW program when we start this co-learning program with the partners. So we begin with the RE-lawyer. So we call ourselves RE-lawyers at West Coast. So the RE-lawyer starts doing their homework, and they read a whole bunch of stories, and they're talking about those stories with, the representative from that nation, who we call the community guide. So the RE-lawyer works very closely with this community guide on stories. They do their homework together, talk about those stories. There could be like 100 to 200 stories. And then after all of that homework, they'll go into the community and have what they call focus groups and talk about these stories with the knowledge holders on answering the specific issue that they're looking at. So if that's scarcity in fisheries or fisheries governance or watershed management, whatever the issue is, and we focus on environmental issues at West Coast, whatever it is, we support with, looking to the stories to kind of answer those big questions that they have. And then once that work's done, meeting in community and reading these stories, talking about these stories, we create a legal synthesis report. So whether that's like 100 to 200 page report, as well as a community version of that report. So that would be about 20 to 30 pages. Then we, take this report and all of these learnings that we took on from the last year or two and go and talk with the decision makers. So whoever that is with that particular nation, be like, we have all of this information now. What's next? What's the big question that you're looking at? And then that's when we really start focusing on supporting with strategy. And I think we also talked about this in the webinar today about all of these different tools that are available to us, these different resources to reimagine this better future. So that's also what the RELAW support with is building knowledge on these tools. So in BC, one particular tool that's coming up is DRIPA. So, the UNDRIP Act in BC. So different things like that. So we kind of see ourselves as bridging Canadian law and Indigenous law. And we take on this journey on learning that particular legal tradition, but also with, our own knowledge of the Canadian legal system to support in the process. So really we focus on a deliberative source of law. So having dialogue and supporting in that dialogue to reach solutions. And I'll put my email in the chat and you can send me an email and yeah, we can talk from there. Thank you.
Great, Rayanna. And I think looking at the clock, this is getting to our time. And I'd really like to thank all of the panelists and all of the audiences for, an amazing 2 hours. This is work that many of us do every day, and to have the opportunity to reflect and to share with a group of brilliant practitioners and an absolutely delightful audience has been a real privilege. To close us out, again, this is a webinar series, so there will be more. Watch the Conservation as Reconciliation website, our Twitter and Facebook feeds for updates. We'd also like to again thank our sponsors, the West Coast Environmental Law, and of course the CRP Partnership, and all of those who've volunteered their time to be with you today for their contributions. And I'll leave it to Elder McDermott to close us out in a good way. So, Masi.
You're on mute, Larry.
Someone had to do it.
Okay, I'm back. A little technological, it was more than mute, but okay, I see I've got about 4 minutes, I think, Larry. What I want to bring up very quickly is I was sitting here and I went to an isolated spot. I've got construction going on in the building. I came across this newsletter we wrote in 1993. And just very quickly, the quincentennial began, this is 1992, in typical tunnel vision as a celebration of discovery and conquest, but has become, after a wide and cantankerous debate, a victory of recognition for Indigenous peoples and the idea of variety of points of view. On October 12th in New York City, at the site of 3 wooden caravels that the Spanish Navy recommissioned and sailed across the ocean for the quincentennial, a dozen Native leaders received a declaration of respect for Native cultures and peoples. Spain decided not to celebrate Columbus, but Native American concerns. It signaled a new relationship. Indigenous peoples have suffered the most because of conquest, Mazzaro said. It is time their voices were heard. I'll jump ahead. So Chief Jenk Swamp, Mohawk of Akwesasne, not far from here, accepted the ship's pennant, a sign of honor and awarded at the captain's discretion. Quote, "The work of peace and reconciliation requires a great deal of courage," said the chief, who in return gifted the Spanish dignitary with a Mohawk sweetgrass basket. And then in '93, the first Indigenous Nobel Peace winner, Rigoberto Menchú, was honored, etc. So it was interesting to see what was going on almost 40 years ago. For me, it's a reminder of how long our people have worked to balance the canoe and how hard we have to continue to work, because for every 2 steps forward, there's 1 back. One might argue the ratio is the opposite, but I just wanted to share that. I want to say Chimigwech to everyone who made this sharing occur. Awesome speakers. I found it easier to sit back and let this bright young talent just share with such clarity and strength. It's it's very encouraging for those of us who are gray in the hair and long in the tooth, as they say. I'll close by as following. Kwekwe Kijimanadu Chimigwech Chimigwech Anik Mishomas Benung Chimigwech Kakina Kegogya Ziduin Chimigwech. To everyone, I ask that the Great Spirit Kijimanadu keep you healthy and safe, and until we meet again, I pour our nibi, our water, on our council fire, and say miigwech to all of creation.
Masi Larry. And everyone, thanks again for joining, and be well.